The Shell and Mineral Resources and Energy Minister Gwede Mantashe this week applied for leave to appeal a ruling which blocked a seismic survey of the Wild Coast. Now, the Makanda High Court set aside the decision by the minister to grant Shell the exploration right. Let's then look at what this latest installment in this matter that has been going on for quite some time now mean for this particular case. Wilmien Wicomb is the attorney from Legal Resources Centre and joins us live now. Thank you so much for your time, Wilmien. Let's talk about, the latest development. Shell and the minister have now applied for leave to appeal. How do you first react to that?
Well, not surprised. I think it is, it's a very important judgment that came from the Makanda High Court and far-reaching. So I'm not surprised that both the minister and Shell, and in fact Africa separately, all applied for leave to appeal.
And are you confident, given the judgment? I mean, also talking about how there were several procedural issues here, and we'll get to them in just a moment. Are you satisfied, though, that right now, as it stands, you'll be able to successfully argue against this leave to appeal being granted?
So there are two steps here. It's first the leave to appeal and then the actual appeal. So leave to appeal, the test would be whether the court thinks that there are merits, that there's a possibility for an appeal to succeed, and whether there's great public interest. And so on those two grounds, they may get leave. And I think the public interest is obviously quite a significant one. And then only will we actually argue the appeal, where if that goes ahead, we certainly feel very confident that we will win any appeal if it comes to that.
Especially because, when you look at the issue of public interest, the court arguing that, there hadn't been effective communication or even, public consultations with the community of the Wild Coast around this particular issue. I'm certain the community is watching this with bated breath. Have they reacted to this latest development around, the application for leave to appeal?
Yes, I mean, they've been quite busy since the review application and the successful judgment, because both Petroleum Agency of South Africa and the minister has been, going around the country speaking to not only applicants in this case, but all fishing communities up and down the coast. It's clear there's a very big campaign to try and win over fishing communities, but certainly our clients in this case and on the West Coast say that they do not see any benefit for themselves and they won't agree to this.
And this particular process of consultation, talk to us about this, as you say that it's been almost far and wide now, and you say that it's covering various bodies here as well. How has it been received on the ground? I know you say that the communities are saying there's no benefit for them, but let's talk about the engagements. How did they go?
So I wouldn't call them consultations. So they're really big jamborees, if you will, where people in favor of oil and gas have been addressing communities to try and convince them that this is beneficial. And one of the big messages that have been coming across from the minister and from PASA is this idea that it is now the time for South Africa, for the indigenous people of South Africa to benefit from the resources, whereas in the past, it was the colonial powers who were able to benefit from our resources. Now, it appears a curious message, given that the companies getting access to the resources are certainly not indigenous. They're from, they're Shell and Total and other such international, multinational corporations. So there's a lot of skepticism, certainly from the communities, as to these messages that they're getting.
I suppose also the real concerns around the issue of climate change as well, which came out in court. I mean, even Shell arguing that it's too soon to even take things there.
That is what Shell was arguing. And, there's an attempt to separate exploration for oil and gas from the actual drilling for oil and gas, and to say, well, you can't take into account the impacts of actual drilling for oil and gas, that's a difficult argument. I mean, there's only one reason why you explore for oil and gas, and that is in order to drill for oil and gas. So it's quite superficial to separate the two. And we know from experience, certainly in South Africa, that once exploration has been successful, and our legislation really binds the minister to award mining rights rights for oil and gas drilling when exploration has been successful. And so, you know, communities are saying you can't separate the two and pretend that climate change will only become an issue when you get to the drilling phase.
And I suppose one can say that it's not a surprise that things got to this point where tensions are laid bare once again, because we also saw the case of Kolobeni. I'm sure even the residents referring to it when they talk about, you know, the mining issue, saying you cannot separate the two, because I'm certain they feel that they've been hard done for quite some time. That's why they even now want to even merge the two to kind of highlight their desperation. Do you get a sense that that is?
Yes, I think so. And I think that speaks to kind of the heart of what this Shell case has been about. And that's about the decisions being taken by the minister as regulator and the communities feeling that they are the ones affected. And the decision makers are not taking them and the impacts on their land rights and their lives into account. They cannot trust the decision maker, in effect. And you know, as you say, Kolobeni was a good example of that. And in this case, really, that's what we asked the court to do, is to set down guidelines for how decision makers should take decisions, so that, you know, communities can trust them again, because at the moment they don't.
Could we see a case, for example, where your clients, when these particular regulations are then set out, could we see a possibility of them working together, and that's possibly agreeing to work with government on this one?
Of course, anything is possible. And, you know, if there is the kind of engagement that is actually envisioned by the Constitution and even by our legislation, then anything is possible. But at the moment, there's real mistrust, and for good reason, because that engagement is simply not happening.
All right, let's see then how this one plays itself out, because, you know, as you say, it's still an application for leave to appeal. Should that be granted, then we'll see a full-scale appeal, because it was indeed a very, very, you know, far-reaching judgment that the court had put out there, and thus scathing on the other side. But let's leave it there with you for now. Thank you so much for your time. That is Wilmien Wicomb, an attorney from the Legal Resources Centre.